Welcome to my new video. If you're a business owner, startup founder, or content creator and you're wondering who really owns a copyright, or do I need a license to use music in my business, this video is for you. Today, we're going to break down key copyright ownership rules in a simple and practical way. Whether you're launching a brand, running a media business, or producing original content, understanding these basics is crucial for protecting your intellectual property and staying compliant. So let's get started. Question No. 23. Who is the first owner of copyright in a work? Answer. Ordinarily, the author is the first owner of the copyright in a work. The term author refers to the individual who creates the work, and this encompasses a wide range of creative fields. The author is typically the person who has contributed the original expression or idea that makes the work unique. Examples of authors include writers, composers, artists, filmmakers, and creators of software, photographs, and other original works. The ownership of copyright initially rests with the author because copyright law is designed to protect the intellectual property rights of creators, allowing them exclusive control over the reproduction, distribution, performance, and adaptation of their works. Question No. 24. Who is the author? Answer. The term author is defined differently depending on the type of work. According to the Copyright Act of 1957, the author is generally the person who creates the work. However, the specific identity of the author can vary depending on the nature of the work. Categories of works and their authors. 1. Literary or dramatic work. The author is the person who creates the work. This includes authors of books, articles, poems, plays, scripts, etc. Example. If someone writes a novel or a play, they are considered the author of that literary or dramatic work. 2. Musical work. The author is the composer of the music. The composer may create both the musical composition and arrangement, including lyrics, melody, harmony. Example. The person who composes a piece of music, e.g. Beethoven for his symphonies or a contemporary composer for a new song, is the author of the musical work. 3. Cinematograph film. The author is the producer of the film. While other contributors, like directors, writers, actors, etc., play significant roles, the producer is legally considered the author for copyright purposes. Example, in the case of a film, even though multiple people contribute to its creation, the producer is regarded as the author under the Copyright Act. 4. Sound recording. The author is the producer of the sound recording. The producer is typically the entity or individual responsible for creating or organizing the recording, such as a music producer in a studio. Example, the music producer who records and produces a track or an album is considered the author of the sound recording. 5. Photograph. The author is the photographer who takes the photograph. The photographer is regarded as the creator of the image, regardless of how the photograph is later used or distributed. Example, if you take a picture using a camera or smartphone, you are considered the author of that photograph. 6. Computer-generated work. The author is the person who causes the work to be created. This applies to works that are automatically generated or produced by a computer without direct human intervention, but where someone has initiated or programmed the process. Example, if a computer program generates a piece of music or artwork, the person who programmed the computer or caused it to create the work is the author. Important notes. 1. Joint authorship. If a work is created by 2 or more people, each of them is considered a co-author of the work. In such cases, the rights and ownership are typically shared unless an agreement states otherwise. 2. Works made for hire. In certain situations, such as when an employee creates a work within the scope of their employment, the employer is considered the author instead of the employee. This applies to works created by employees in the course of their duties, like a software developer coding a program for a company. 3. Creative control versus legal ownership. While someone may be the author in a creative sense, the legal ownership, i.e., copyright ownership, may belong to a different entity, such as a production company, publisher, or employer, especially in cases of works made for hire. Question No. 25. Is it necessary to obtain any license or permission to use a musical sound recording for public performance? Answer. Yes, it is necessary to obtain licenses or permissions to use a musical sound recording for public performance. This includes a few important steps and stakeholders. Key points to consider. 1. Licensing requirement. When you plan to use a musical sound recording for public performance, such as playing a song at a concert, on the radio, in a restaurant, or through a streaming service, you must obtain a license from the copyright owners of the work. This is required to ensure that the rights of the creators and owners of the work are respected. 2. Copyright owners of a sound recording. The copyright in a musical sound recording is usually owned by several parties, and it's important to obtain permission from each of these parties. O. Producer of the sound recording. The producer who financed the recording and owns the rights to the specific sound recording itself must grant permission for its use. O. Lyricist, for works with lyrics. If the musical sound recording includes lyrics, the lyricist, the person who wrote the lyrics, holds the copyright in those lyrics and must give permission for their use. O. Composer of the music. If the recording includes music, the composer, who created the music, also holds rights to the musical composition and needs to grant permission for its use in a public performance. 3. Types of licenses. The permissions or licenses required are generally of two types. Public performance license. This license is needed when a sound recording is played publicly, for example, in a public event, concert, club, or on the radio. In India, these licenses are typically issued by performance rights organizations like IPRS, Indian Performing Rights Society, or PPL, Phonographic Performance Limited. Mechanical license. This license is needed when the sound recording is reproduced or distributed, such as for making copies of the recording for sale, streaming, or downloading. These licenses are generally obtained from the record label or producer of the sound recording. 4. Licensing process. O. Performance rights organizations, PROs. In many countries, including India, PROs like IPRS and PPL manage the collection and distribution of performance royalties to the creators of musical works. To legally play a musical recording in a public place, businesses or individuals must contact the relevant PROs to obtain a public performance license. IPRS, Indian Performing Rights Society, handles the licensing for musical compositions and lyrics, while PPL, Phonographic Performance Limited, manages the licensing for sound recordings. In some cases, both may need to be contacted to obtain the appropriate licenses for public performance. 5. Impact of unauthorized use. If you use a sound recording in public without the proper license or permission from the copyright holders, producer, lyricist, composer, or through a PRO, you are violating copyright law and may face legal consequences. Copyright owners have the right to claim damages or take legal action against unauthorized use. For more detailed information, visit the official website of VMK Professionals, www.vmkpros.com, and always review the latest amendments before execution, as laws keep changing frequently. Question No. 26. Who holds the copyright in works created by journalists during the course of their employment? Answer. When a journalist or any author creates a literary, dramatic, or artistic work as part of their employment with a newspaper, magazine, or similar periodical, the copyright ownership is split between the employer and the author, depending on the nature of the use of the work. Legal provision. This is governed by Section 17C of the Copyright Act, 1957, which deals with works created under a contract of service, i.e., an employment relationship. Ownership explained. 1. The employer, e.g. newspaper proprietor, is the first owner of the copyright, but only for specific purposes, such as publishing the work in the newspaper, magazine, or periodical for which the journalist works, reproducing the work for publication in those specific formats. 2. The author, i.e. journalist, retains the copyright for all other uses, unless otherwise agreed in writing. These rights may include republishing the article in a book or anthology, using the work for a film adaptation, digital compilation, or independent publication, licensing or assigning the work for non-journalistic purposes, if not restricted by contract. Key phrase to understand: in the absence of any agreement to the contrary. If the journalist and the employer have a written contract that assigns full rights to the employer, then that contract will prevail. However, in the absence of such an agreement, the default rule of shared ownership applies as per the Copyright Act. Question No. 27. Who owns the copyright in a work produced during the course of the author's employment? Answer. When a work is created by an author in the course of their employment under a contract of service or apprenticeship, the employer is considered the first owner of the copyright in that work, unless there is an agreement stating otherwise. This is based on Section 17B of the Copyright Act, 1957. Key points explained. 1. Contract of service versus contract for service. A contract of service refers to an employment relationship where the author is an employee. A contract for service refers to a freelance or independent contractor arrangement where the creator typically retains ownership unless otherwise agreed. 2. Employer's ownership. If the author is employed, e.g., a graphic designer at a media firm, and the work is created as part of their job duties, the employer becomes the first copyright owner. This means the employer has the exclusive right to reproduce, publish, or commercially exploit the work. 3. Exception. Agreement to the contrary. If there is a written agreement that explicitly states the copyright will remain with the employee or be shared, then that agreement takes precedence. 4. Apprenticeship. If the author is working under an apprenticeship, i.e., training under a skilled professional, and creates the work as part of that training, the trainer-employer will be the first owner. Again, unless there is an agreement to the contrary. Question No. 28. Who is the owner of the copyright in the case of a work produced for valuable consideration at the instance of another person? Answer. According to Section 7C of the Copyright Act, 1957, if a work is created in return for valuable consideration, i.e., payment or compensation, at the request or instance of another person, then, unless there is an agreement to the contrary, that person, the one who paid for or commissioned the work, will be considered the first owner of the copyright in the following types of works: photograph, painting, portrait, engraving, cinematograph film. Breaking down the key terms. 1. Valuable consideration. This refers to money, payment, or any kind of compensation provided in exchange for the work. It shows that the work was not done voluntarily or as a gift, but as a commissioned project. 2. At the instance of another person. This means the work was requested or commissioned by someone, an individual or organization who paid for it to be made. That person initiated the creation of the work. 3. First owner of copyright. The person who commissioned and paid for the work is considered the first copyright owner, unless there is a contract specifying otherwise. Question No. 29. Is copyright assignable? Answer. Yes, copyright is assignable. This means the owner of the copyright, whether in an existing work or a future work, can legally assign their rights to another person or entity. The assignment can be complete or partial, and it can be subject to specific terms, conditions, and time periods. This is governed by Section 18 of the Copyright Act, 1957. Types of assignments. 1. Existing work. The copyright owner can assign rights in a work that already exists, e.g., a book that has already been written or a song that has been recorded. 2. Future work. A person who intends to create a work in the future, called a prospective owner, can also assign the rights to that future work. However, the assignment takes effect only after the work comes into existence. What can be assigned? The copyright owner can assign the following: all rights, wholly, or some rights, partially. Rights geographically, e.g., only for use in India or internationally. Rights for a specific medium, e.g., only print rights or only film rights. Rights for the entire duration of copyright, or for a limited time, e.g., 5 years. Rights exclusively or non-exclusively. Conditions for valid assignment. Under Section 19 of the Copyright Act, a valid assignment must: 1. Be in writing and signed by the assigner, the person assigning the rights. 2. Clearly specify, the work involved, the rights being assigned, the duration of the assignment, the territory to which it applies, the royalty amount or other consideration, if any. If duration or territorial extent is not specified, the duration is presumed to be 5 years. The territory is presumed to be India only. Question No. 30. What are the methods or modes of assigning copyright? Answer. Under Section 19 of the Copyright Act, 1957, any assignment of copyright must follow a formal legal procedure. The law requires that a copyright assignment must be: when writing and signed, the assignment must be in writing, and it must be signed by the assigner, the person transferring the rights, or their duly authorized agent. Oral agreements are not valid for copyright assignment. 2. Identification of the work. The agreement must clearly identify the work for which copyright is being assigned. Example, if it's a novel, the agreement should state the title of the novel. 3. Specific rights assigned. It must specify exactly which rights are being assigned, such as right to reproduce the work, right to perform or broadcast the work, right to adapt or translate the work, right to make a cinematograph film, etc. 4. Duration of the assignment. The agreement should mention the period for which the rights are assigned. If the duration is not specified, it is legally presumed to be 5 years from the date of assignment. 5. Territorial extent. The agreement should mention the geographical area where the assigned rights can be exercised, e.g. India, worldwide. If this is not specified, the law assumes that the assignment is valid only within India. 6. Royalty clause. The agreement should include the royalty amount or percentage, if any, payable to the original author or their legal heirs. This ensures fair compensation for continued use or commercialization of the work. 7. Provision for revision, extension, or termination. The assignment agreement should contain clauses that explain when and how the agreement may be renewed or extended, under what conditions it can be revised or terminated. These terms must be mutually agreed upon by both parties, assigner and assignee. If you want to register a copyright for your work, contact VMK professionals today. We'll help you protect your creativity with a smooth and hassle-free process. Visit www.vmkpros.com or call us now to get started. That's it for this video. We hope you learned something new today about who owns copyright, what an author is, and how licensing works in India. Don't forget to like, share, and subscribe to our channel for more easy-to-understand legal content. Thank you for watching. See you in the next video.